Now, we are running one provocation each day this week, so let us kick off our week with some rethinking about the justice system. And who better to offer her thoughts than the former president of the Supreme Court, the UK Supreme Court, Baroness Hale.
Lockdown has forced the courts to find ways to ensure that urgent cases can still be heard, some of them pretty makeshift. But it has taught us some valuable lessons about what is and is not important to a fair hearing, one which not only produces the right result, but is felt to be fair by the judges and the lawyers and by the people whose cases these are. This gives us the opportunity to rethink how we do trials in all kinds of cases. We do have some sacred cows. Our reliance on oral hearings, oral evidence, oral argument, and in many cases oral decisions. Our belief that a witness's demeanour and body language can reveal whether he or she is telling the truth. And perhaps above all, our faith in trial by a jury of 12 randomly selected members of the public as the greatest protection against the wrongful conviction of the innocent. Routine case management decisions can be taken in writing or remotely, as can uncontested matters such as debt collection, divorce decrees and guilty pleas. But anything contested is a different matter. As Celia Kitzinger says, there is a gravitas attached to a courtroom hearing, the formal architecture and courtroom layout, the elevated and distant seat of the judge, the familiar rituals, and the sombre clothing. All are evidence of the seriousness and impartiality with which decisions are made. All are lost if everyone is appearing remotely on small screens from their own homes or offices. That feels more like a case conference than a judicial process. Also, as an unnamed family court judge says, he or she is deprived of all the usual ways of creating an atmosphere of trust, fairness and compassion. Reassuring smiles, listening intently to what the parties are saying, assessing their level of anxiety and nerves. It is all too easy for the professionals to forget that the lay parties are there and listening if they cannot be seen. Trials should not be experienced as a conspiracy of the lawyers against the laity. Some of these problems could be cured by providing much more sophisticated platforms for remote hearings, but not all. And what about face-to-face encounter when witnesses give their evidence? Children and vulnerable witnesses can already give their evidence by video link. Some think that this is not as powerful as giving it in the courtroom. It looks like television rather than reality. But could there be advantages in separating the witness and the cross-examiner? Less intimidating and confusing? Should we invest in more and better video links, or in larger courtrooms? And what about face coverings? We are reluctant to allow Muslim women to give evidence wearing the niqab, the face veil. I found it easy to tell whether a mother was telling the truth once she had taken off her veil. But could we allow or require witnesses to wear non-surgical masks, which everyone using public transport now has to wear? And might face masks be the answer to jury trials? A good jury turns into a little community, working together in the interests of justice. This is lost if they are operating remotely, or even at a social distance in a courtroom. But a more radical solution would be to rethink why and when we need a jury trial. The great advantage of trial by judge alone is that the judge has to give detailed reasons for his decision. But judges can get case hardened. Better still might be a judge sitting with 2 lay people, rather like the jurat system in the Channel Islands. So we do have a golden opportunity for a radical rethink of how we do trials. Let's hope it is taken.